estate planning, because that is your freedom to do with your property what you want, when you want, and the way you want. And any tax saving that you can come up with, and that's what our job is as attorneys. You got something you want to add to that, Craig?
Well, we're talking about, in part, preservation.
Okay, we're going to talk about creation, preservation, and distribution of wealth.
And so living in a retirement area, the preservation is so important because you work, you accumulate wealth, your nest egg, and then you go through the golden years. And you want to preserve your assets so that you have enough at least to pay for your own way. The problem with the golden years is they start to tarnish for many people as we get older. And there's a song that I heard a while back by John Hyatt called Robber's Highway, and how you transition through life and you're being robbed of things. Our health, our ability to walk, our ability to see, ability to hear. We have to have assisted living. We're being robbed of our money. But the key is, to the extent we can, we preserve it, and we want to pass it down to our loved ones. And that's a major part of the estate planning process.
I know you're going to say, well, what are you talking about? I worked hard to get this money. I want to keep it. Well, I've got news for you. You can't take it with you. In fact, I'm going to write a book, and that's going to be the title of it. Remember, you can't take it with you. So you've got to figure out what to do with it, and that's what you've done when you made your will or your trust. And that's our job, is to help you do that in an efficient way. No matter what happens, and this is something that most people don't think about, you're going to have administrative costs and maybe have estate taxes. You'll certainly have income taxes. Part of our job is to fix it so your last year income taxes will be as low as we can. Right?
The estate taxes, I think of it as death taxes. And traditionally, there's been three different death taxes: the inheritance tax, the state estate tax, and then the federal estate tax. We'll be talking more about the federal estate tax exemption pretty soon. But most states have done away with inheritance tax. When I practiced in Illinois in '84, we did away with the inheritance tax, purportedly to prevent the wealthy retirees from leaving the state of Illinois, so that they would not have their estate subject to estate tax if they stayed in Illinois. Well, come to find out, they were really leaving Illinois because of the cold weather. But there's only 9 states left that have inheritance taxes. Nice thing about Arizona, this time of year, great place to live, it's a great place to die. No inheritance tax, no state estate tax. And so the only death tax you may be faced with is the federal estate tax. And we'll be talking more about that momentarily.
There's 3 ways you can handle things. If you don't do anything, you're going to have what we call intestate succession. That's a fancy word for no will. The second step is doing a will, and the third step is doing a revocable living trust. A lot of people like to think about using joint tenants with right of survivorship or community property with right of survivorship, but that does not make a distribution. It just takes care of the problem. When one person dies and when the next dies, you don't know what to do. One time I was doing a seminar like this, and the guy said, well, I know what to do. As soon as she dies, I marry a younger gal, put it in joint tenancy or community property with right of survivorship. Her and his wife whacked him really big on that one. But anyway, that's where we're at.
Well, one thing about the living trust, because they are so marketed anymore, and perhaps one unfortunate aspect of the marketing of the living trust is because we have document preparers, non-lawyers, marketing living trust. And they do so in large part because they sell investment products, an annuity. So they have seminars to draw people in to explore the possibility of a living trust. What they're really after is your investment portfolio. But so many people think that the living trust is the only way to avoid probate, and it's not. You can have a simple will. Say I have 2 kids. I have a simple will that leaves everything to my 2 kids. I put my 2 kids on my home in a beneficiary deed. So upon my death, They record my death certificate, now they own the home, no probate. I go to the bank and I name my two children as POD payees. I go to the brokerage firm and name my two children as a transfer on debt designees. No probate. So the trust is not the only way to avoid probate.
Actually, sometimes the trust can be a problem. Craig probably you remember the Racy Daisy Trust? You'll remember when I tell you. There was an insurance salesman that wrote a book that's called Daisy Trust. And his idea was that every time you bought a property, you've made another trust for it. So if you had 10 properties, you had 10 trusts. Total nightmare, so don't get involved in something like that.
But there is a way to deal with that. From time to time, we'll have a client that'll have multiple properties. They rent properties, for example. And they want separate entities for each property. So we can do a simple LLC for them and then name the trust as the member of the LLC. So each of the LLCs has the same trust as the member. But each LLC protects the property and just that property from any liability that might arise. So and they're shielded from personal liability.
That's a good move. We already sort of talked about joint tenants with right of survivorship and community property with right of survivorship. The difference is community property with right of survivorship can only be done between spouses. The other thing that happens with community property with right of survivorship, when one spouse dies, you get a step up in cost basis on the whole thing. That's a unique thing to Arizona. It doesn't happen in Illinois, as you know well.
Yes, sir.
And so the advantage there, one of you dies, when you sell the house, you get a full step up in basis. If you had it in joint tenants with right of survivorship, you'd only get a half a step up in basis, and your capital gains tax would be on half the gain. So you want to get out of that, and that's something that we can help with. That's the Maricopa County Courthouse. It's an imposing looking building. You can see there's no handicap facility for getting into that thing. Actually, you go around behind the stairs and sort of go through a tunnel, but anybody that goes there by themselves for the first time, me included, it used to be that top floor was the old county jail. As a young lawyer, I went up there a few times. That was a scary proposition.
Did you go there as a lawyer or a defendant?
As a lawyer. And I always hoped I'd stay a lawyer. Or those doors are clanging up there. That's okay. We're ready for this.
One point though about that building, a friend attorney of mine in Sun City, who's now retired, he had pictures of the old courthouse with horses and buggies in front of it. Amazing picture.
With what in front of it?
Horses and buggies.
Oh my goodness. It's been there since horses and buggies. Okay, now we're ready for the probate costs. These are generalized probate costs, but this was the law in Arizona until 1973. The attorney got 3% of the first 100,000 and 2% of each 100,000 after that. In 1973, that was changed to reasonable attorney's fees. That means we can ask you for more than those numbers, and many attorneys do. So this is a good reason to stay out of probate. You can see that when you get up to $1 million, it gets pretty steep. So,
yeah, well, I will say though that the probate process in Arizona is probably the simplest of any state. There's maybe 16 states that have adopted the Uniform Probate Code, and Arizona is one of those. And we have a thing called informal probate, where probate can be processed from start to finish without a need for a formal hearing. Unlike California, where I was involved on the sidelines watching one, took 2 years, $68,000. That's pretty much unheard of here. And Sam's right, we can't charge percentages anymore. And the personal representative cannot charge percentages anymore, although some probably do. So you keep track of your hours. How many hours it takes one person to do something may differ a lot from another. How much they charge per hour may differ a lot. So the probate costs can become significant. If you listen to the WOW station, as you drive around 95.1, the good old music from the 50s, 60s, primarily 60s and 70s, you hear the commercial from the company in Scottsdale that's peddling trust. If your estate ends up in probate, it's going to cost tens of thousands of dollars and it's going to take years to complete. I'll tell you, that's not the case in most probates. But to the extent you can avoid court involvement, lawyer involvement in the administration of the estate, reduces costs, and it makes the administration more efficient.
Time required for probate. That's one of the reasons to avoid probate, is because it extends the amount of time. Because you've got to give 4 months notice to creditors. That means if you have a probate estate, it will be open for at least 4 months. Our practice, and I'm sure Craig does the same thing, we try to get them done in 6 months. Most of the time, we're fairly successful. The place where you run into problems in probate, I find, is where the kids cannot agree on the price for selling the house. Sam's rule is the kid that's the furthest away thinks it's worth the most money. And that's something that you need to think through how that's going to happen if you still have a house. Yes.
So our furthest kid is in Wisconsin. The other two are here in Scottsdale. The middle child who lives in Scottsdale is the one that is going to be in charge of our estate after we pass. Can we put a cap on the house, that the house will be sold at X amount of dollars? Not that they would disagree, but then you never know.
You can do that, but we don't recommend you tying their hands. He's a dictator. If he's the successor trustee, what he says goes. The way to avoid a problem with that, though, is for him to send a letter to his brothers and sisters and say, this is what I intend to do. If you have any objections, let me know in the next 30 days. And then he's home free, so if they bring some sort of action, that'll be looked at. Well, he told you that's what he's going to do, and it won't get too far.
What he might do too is just get an appraisal. And the appraisal can be important for another reason, because Sam's already mentioned step up a basis. So you have a home that you paid $200,000 for, at the time of death is worth $500,000. The death brings about a step up a basis. So the basis now is $500,000. So when that home sells, the capital gain is based upon a basis of $500,000 compared to the sale price. Usually the homes are sold within 3, 6, 9 months, and there's a presumption then that there's no capital gain. But sometimes they're held for a longer period of time where there could be potential capital gain, and that appraisal could be important in establishing the basis in determining the gain.
Intestate successions in the yellow box. That's an estate plan by default. In other words, if you don't write a will, the state has written a will for you, but it may not give your property where you want it to go. It may not put the right people in charge. And it does not avoid probate. And it may get your property to the wrong heirs. This happens particularly in second marriages where there's no will. You've got kids from the first marriage and kids from the second marriage. When the second to die, the kids of the first marriage are cut out under the probate statute, so not a good move.
Yeah, I'm involved in a intestacy right now where the lady died here in Sun City West. She had no children, no siblings. Her parents were deceased. And I was contacted by her cousin to proceed with the probate. Well, come to find out, he's the maternal relative of her. So I said, who's on the paternal side? And her father, who was deceased, had 8 siblings. And 5 of those siblings are still alive. 3 are deceased, leaving children. So we have all these heirs now on the paternal side, and we're going to be filing a petition with the court to have the court adjudicate the heirship. But it can be somewhat involved, just identifying who the heirs of one's estate is. It's the first time I've been confronted with that complexity. We actually hire an investigator to go out and search these people down.
Anyway, that's the problem with relying on intestate succession. Next thing is last will and testament. What a will is basically a letter to the judge with a whole bunch of formalities. If you don't do it right, it's not gonna be valid. You gotta have two witnesses. You gotta have a notary. If you don't do it, it doesn't work. But it says, "Dear Judge, please distribute my estate to the following." Usually it's my spouse first, then children, then your charities, and that's where the Boy Scouts fit in, or any church or any other charity that you want to have. No matter how much you want to give to a charity, if you don't put it in your will or your trust, it doesn't happen. Advantages and disadvantages of a will. Wills are cheap. They're not as cheap now as they used to be. When I started practicing, the firm I worked for did wills for $25. And if we were doing a PI case for them, their will was free. That doesn't happen anymore either, but wills are still cheap. They're easy during your lifetime. They're not like a trust. You don't have to transfer your house to the trust because the probate court will take care of all that. But it's simple during your lifetime, and that's what some people are looking for. And the results are now guaranteed. It's not like the intestate thing where Craig has to go hire an investigator to check out all the beneficiaries. Disadvantages. A will, if there's an estate, always requires probate. And he told you how you can avoid there being an estate, which works in smaller cases. But remember, I brought up the racy-daisy thing where you have 11 trusts. You don't want to have multiple problems like that. Disadvantage, more expensive for the heirs. That's because you're hiring me or Craig to go to the courthouse a time or two and draft a whole bunch of pleadings that have to be filed, even with the easy style probate. There's substantial time delays. That's where the 4 months notice to creditors comes in. And it's a public process. And the public process is the one that really bugs me the most because I don't do it anymore, but I used to go to the records and I would see the same people sitting over in the corner, particularly on days after the obituaries were published, checking that. If you got an obituary published, you probably own some real estate, so they're checking out the real estate. And the odds are pretty good that the heirs have no idea what the value of the real estate is. So they lowball the heirs. They think, oh, mom and dad owned this for 50 years and they paid $100,000 for it. 300 looks like a great number and actually it's worth $1 million. And that's the kind of people that use the public records against you. So to keep stuff off the public record is an important part of the process. And that's what a trust does for you, correct?
Yeah, the public part that probate creates is an ideal forum for any creditors to file claims against the estate. Now, that's not to say if it's a trust and there's no probate open, that's not to say that the successor trustee is not required to pay the debts. But I've had situations before where the person died and he had some beneficiary designations and there was no effort to pay any of the bills because all the assets went immediately to the named beneficiaries. Under our probate law, a creditor has the right to open up an estate if none is opened up within 40 days. I've never seen a creditor do that here. The other thing I just want to mention is that I've had people come in with large estates, clearly going to be subject to probate, and we talk about trust, and they say, we don't want a trust. We have no children. We're leaving our estate to charities. We don't care. We're going to use as much as we can during our lifetime. Whatever we leave behind, if it goes into probate, we don't care. All they want is a simple will.
So the general rule is if you have a will, you will have a probate, then it goes to your heirs. And the exceptions are, we've talked about them already, joint tenants with right of survivorship, small estates, which we didn't talk about, revocable trust, which we're going to talk about, and beneficiary deeds that Craig kind of mentioned, you want to talk about small estates, Craig?
Yeah, I came out here in 1987 from Illinois, and at that time, there were two numbers that were important in connection with probate. One was $30,000, one was $50,000. And the significance of those two figures was this. If I died back at that time and I had bank accounts and investments that exceeded $30,000 and they were in my name alone, then my estate, my will had to be probated. Let's assume I just had a simple bank account and I had an average balance of 4,000 or 5,000, well under the 30. But I owned the home that had a value in excess of 50,000. That was the significance of the $50,000 figure. Then my estate would have to be probated. All these years have transpired, and guess what? That $30,000 is now $75,000. The $50,000 is now $100,000. These are pathetically small numbers, and there's no home around here that has a value less than $100,000. But if your estate is under, I mean, every once in a while, we just had one recently where the lady left assets, a couple of accounts outside of the trust, but they only totaled $45,000, $50,000. They were solely in her name, no beneficiary. But we could do a small estate affidavit, and it's a simple affidavit that the beneficiary, the successors to the estate sign, and it's submitted to the bank or wherever the funds are, and then the bank will pay those funds over. But that's a small estate.
Revocable living trust is a two-step process. The 2 steps are created. That's what you do with the lawyer. The second was the property transfers. The lawyer usually does your real estate deed for you. But the rest of the transfers, changing the beneficiaries on your life insurance, and changing your investment accounts has to be done by you. The bank's not going to pay any attention to me, and if they did, you want to run away from that bank as hard as you can, because I shouldn't have anything to do with your money. The trustee is the one that manages the trust while you're living. That's you. The grantor creates and funds the trust. That's you also. And you select the successor trustee and you name the beneficiaries. And then the beneficiaries, that's you as long as you're alive. And it's whoever you put in the trust and your charitable people over there. So that's basically why we put a triangle up, because initially you wear 3 hats, and as things progress, you go down the line, getting more done. Craig?
Yeah, when somebody asks me what's the disadvantage of having a trust, I point out to them step 2. Because if you have a will that leaves everything to the 3 kids, you sign the will and you're done. You have a trust that leaves everything to the 3 kids, that's only step 1. Now you got to get your home into it. You retitle your financial accounts, investment accounts in the name of the trust, or you name the trust as the beneficiary of those accounts. But you have to coordinate your assets with the trust. And the thing about the 3 parties to the trust, grantor, trustee, beneficiary, and oftentimes grantor, the word trustor is substituted for it, or settlor, sometimes even trust maker, but it's all the same thing. The person creates a trust. So think about this. John and Mary Jones, they create the trust. They will always be the grantors of the trust because they are the ones creating it. They will not always be the trustees of the trust. Should they become incapacitated, they won't be serving as trustee. Upon death, they will not be serving as trustee. During their lifetime, they will be the beneficiaries of the trust. And during the lifetime of the survivor of the 2, the survivor will be the beneficiary. So John and Mary, they create the trust. They name themselves as trustees. They are the beneficiaries. Time goes on, John dies. Now Mary is a trustee. Time goes on, she becomes incapacitated. The oldest child now is the successor trustee, or whoever they have named. But as long as Mary is alive, all the assets of the trust must be used for her benefit and no one else's benefit. It's not until she dies that anyone else has an interest in the assets of the trust.
Once we decided to do a trust, then we got the transfer process. That's what the home is what the lawyer's going to do. Life insurance, bank accounts, and stocks are what you're going to do or your financial planner will help you with those things. And then any other assets, that could be rental houses, which should be handled up there in the home real estate. Fred?
I'll tell you that the Arizona deed process is quite simple, and it's uniform through all the counties of this state. Well, we got 9 counties, but it's real simple. And when you get involved, at least I get involved from time to time, and involved right now with these people that own property in Washington, and we're doing a deed up there. And of course, different states have different requirements, formats of the deed. Washington has an excise tax affidavit that has to be prepared and filed. Even though there's not going to be any tax liability associated with the transfer to the trust, we got this convoluted, confusing excise tax affidavit form. So it can become involved at times.
Advantages and disadvantages of the trust, we sort of covered that. But the first thing is you avoid court interference. You're not going to have any judge. That's going to make it cheaper because you're not paying me or another lawyer. You're going to eliminate lengthy delays. You're not going to have probate 4 months notice to creditors. And it's private. Remember, we talked about private. That, in my mind, is one of the top things. The disadvantage is going to cost more. It's a nuisance to have a trust. Sometimes people forget they have a trust. I've had clients come in that had a trust and didn't realize that they had a trust, and then they wanted to do a new trust. And there's possible mismanagement. When you're the trustee of your trust, you cannot mismanage it. You can take the whole trust and go to Las Vegas and gamble it away. And I've actually had a client do that. But if you become disabled or you die, and your successor trustee takes your trust to Las Vegas, they mismanage your trust, and they're going to have big problems. And that therein lies one of the problems, is they spent all the money and they undoubtedly have none of their own, so your heirs are in trouble. So choosing the trustee is very important, that you choose a trustworthy person that won't gamble your money away or do other stupid things with it. The way we write most of the trust now is telling them as soon as practical to distribute the property so they don't have a real big investment function. But sometimes when you have incompetent heirs or small children, they're going to have to manage it. That's a whole nother ball of wax, which I'll let you talk about, Rick.
Well, in terms of that slide up there, if you create the trust, you have to keep in mind as time goes on that your trust exists, because your assets will change over time. And if you forget that you have a trust, or you're just not thinking about it, then you sell your home, you buy a new home, and the new home is not getting titled in the name of your trust. End up a probate. Same way with financial accounts. Your investment advisor goes from Edward Jones to Schwab. Now everything is transferred over there, but it was not put in the name of the trust. So you got to be conscious of the fact that your trust exists. People ask me from time to time, what assets are in my trust? And I look at them and say, well, what assets have you titled in the name of your trust? We've had a couple of situations over the years where we put the home in the trust, say for Mr. and Mrs. Jones out here in Sun City West. And a couple of years go by and they're in the bank, and the bank representative says, hey, how would you like to have a home equity loan? Because if you want to buy a car, you just take the money out of the home equity loan and you get a real low percentage interest rate. And Mr. and Mrs. Jones said, okay. Well, as a part of that process, a lot of these lenders require that the home be taken out of the trust and put in the name of Mr. and Mrs. Jones. So when that deed of trust, the mortgage, goes into effect, it attaches to Mr. and Mrs. Jones, not just the trust. Nobody tells them that they need to put the property back into the trust. And we've had a couple of probates over the years because of that.
That's a problem. I actually had a case one time where a lady, at the time we signed her trust, was not feeling all that well. So I went to the bank with her to help her transfer those to her trust. A couple of years later, she died, and they're all in her name. They'd all renewed, and the friendly banker had renewed them in her name instead of in the trust. Her daughter called me and mad as no at him that had happened. I said, hey, I can't help that. That's what happens. So you have to watch your friendly advisors that take care of you.
Another thing that I've noted, from time to time, I'll see a trust that somebody has created, a lawyer perhaps, and it'll have a Schedule A identifying the assets that at the time of the creation of the trust were to be assets of the trust. It will have the address of the home. It'll have bank accounts, investments. And a lot of times, the person then who's creating the trust think that schedule gets those assets into the trust, and it doesn't. The schedule can be very confusing because they think the schedule then, the assets listed are all in the trust. That schedule doesn't do anything in getting those assets into the trust. And then the other thing about that schedule that's a little bit concerning is that time goes on, assets change. So do they have to amend the trust to update the schedule every time they change an asset? And of course, the answer is no. But most lawyers don't have schedules attached. But it is a good idea, anybody that has a trust, to keep a running inventory of the assets that you have in the trust.
Okay, we've got a big chart up here about estate taxes, which I don't think any of us are gonna have to worry with, but let's talk about it. Back in 06, 08, the estate taxes were on any estate over 3.5 million. We did a lot of trust for folks then to double that amount. The tax went up dramatically in 18 to 11 million, and it's gone up to 12 million now, but it's gonna drop to 6 million in 26. And you're gonna say, I don't have 6 million. But if your state is growing and you're young and healthy, you may grow past the 6 million. So the point is to keep your eyes open for what changes in the law, correct?
Yeah, of course, this table here starts in the year 2011. And as I said earlier, I came out here in 1987. And at that time, the federal estate tax exemption was $600,000 per person. So what we did in a husband and wife situation, in most cases, was to have a trust that would split apart upon the death of the first spouse. And that would enable the survivor to be able to allocate half of the trust assets to what we call a B trust, below ground trust. It's actually a decedent's trust. But those assets that were transferred to the B trust would not be a part of the survivor's estate at the time, taxable estate at the time of the death of the survivor. So John and Mary, even though there was a $600,000 exemption, they could shelter together $1.2 million. And then you get in the year 2001, and it went up to $1 million. And before long, it's up to 1.5. And you can see here, 5 million by the year 2011. So for most people, we don't do these AB trusts anymore. And we also have a concept called portability, where the surviving spouse can port over to the surviving spouse's taxable estate the unused portion of the tax of the first spouse to die. So 2026, you see the big drop. But as Sam said, even with that drop, it's going to be more than most of us would have anyway, way more. And I don't think it's going to drop to that. I think it's going to be higher than that. Because when you think about the people that we have in Congress, they're selfish, they're greedy, they're multimillionaires, and they're not going to want their estates, particularly their estates, being subject to estate tax. So it's going to climb up real quick from after 2026.
That numbers for 26, is that proposed or is that $6 million in 2026?
Yes.
Is that proposed or is that what it's
That's
going
set
to
in
be
the law
right now?
right now.
It's in law.
Yeah. Now, there may be some cost of living adjustment to that. I'm not actually sure. But that's the number I keep hearing about, that it'll decline to.
That number is set unless they change it. Income tax, capital gains, IRAs, gifts to charity, on your IRA or 401k, the Arizona tax credit of $400. You still have until Monday to give $400 to a lot of charities and put it on last year's tax return.
Yeah, as you probably know, the standard deduction has just skyrocketed in recent years. And years ago, I would get a solicitation from a charity, and they say, well, this is tax deductible, And of course, what that meant is that if I gave them $100 and I'm in a 25% tax bracket, then there's a tax benefit to me of 25%. So I'm really only giving them 75 cents on the dollar. But for most of us, the amount of contributions, gifts, tithing, whatever it may be, is going to be well below the standard deduction. But for many of us, we have IRAs. And what you can do with an IRA, say I want to give to my church in 2024, $5,000. It's going to be well below the standard deduction. But I can take $5,000 out of my IRA. I have my IRA custodian make the check directly to the church. And it goes to the church. And then for tax purposes, I do not have to report that as income. It is reported on the tax return, but there's a place where you designate that it went to a qualified charity. So I'm not having to pay taxes on it. So that is a tax benefit to me.
Comprehensive estate plan option. We got a whole big list of things here that are really important to talk about. And the very first one is durable health care power of attorney on page 13. If you don't have your health, you don't have anything. So even if you have no estate at all, you should have a durable health care power of attorney so that your agent can speak for you when you're in the hospital or other illness stress. The second one's a mental health care power of attorney, and those are different. And those are needed for all of us. Most of us are not going to have mental problems, but we're set up in case we do. The third one is a living will declaration with an addendum. The living will says basically it has nothing to do with living. It says let me die. And you want to say something on those, Craig?
Yes. If you do not have a healthcare power of attorney in place, then it could very well be that if you do become incapacitated, there will be a need for a guardianship, a court proceeding to appoint a person that can make your medical decisions for you. So a simple healthcare power of attorney does away with the need for a guardianship. The mental health care power of attorney, well, I remember quite well before Arizona passed a law that allows for the mental health care power of attorney. And I would get a call from a spouse or a child from time to time saying my parent or my spouse is over at the SAGE unit here in Sun City West at the Dillard Hospital. SAGE unit is on the 4th floor. It's a psych ward. And they will not allow my spouse or my parent to get in there until we get a court order. So we had to petition the court to have a guardianship with mental health powers. Either the spouse appointed or a child appointed to be able to have the authority to admit the spouse or the parent to the SAGE unit. And then the living will is nothing more than a document whereby you express your wishes that you don't want to live under certain medical circumstances. And you've probably heard about Oregon, the death with dignity statute. Vermont, about 2 months ago, passed a law very similar to that. I hear the phrase from time to time, physician-assisted suicide. And I can tell you that if I'm in Oregon or Vermont and I just don't want to live anymore and I go see a doctor, they're not going to help me in my life. There has to be an underlying basis. And in Vermont, there has to be a diagnosis that you have less than 6 months to live. So there are parameters. But over the years, I've been to most of the nursing homes around here. And if you go in there about 3:30 in the afternoon, 4 o'clock, you'll see a good many of the patients out in the large room. there may be a guitar player, there may be a singer, but some form of entertainment. And many of those people are just sitting there, eyes closed maybe. They don't really understand what's going on. You say hi to them, they may respond, they may not respond, but many of those that respond, they won't remember a half an hour later that they even saw you or remembered you. And they have no quality of life. We keep them alive because they're not in a coma, irreversible. They're not terminally ill, hooked up to an artificial life support and need to be hooked up to an artificial life support. Of course, we can't commit euthanasia. It's homicidal if we do that. But the quality of life is really a problem. And I can tell you, if you live long enough, you're going to have those issues.
We covered the healthcare part. Now the durable financial power of attorney, that's for things that are left out of your trust. Anybody that has a trust needs to have a durable financial power of attorney. And even if you don't have a trust, if you've got a will, that's a good idea too. And then back to where Craig was, nomination of the conservator. In all the documents, you should have a nomination of a conservator for you so that you don't have to go through a court process. Letter of instructions to successor trustee. That's the things that are outside of the trust, particularly instructions about your health care. I want to be kept alive forever, or as soon as I quit having a heartbeat, I'm done. And those are the kind of things that you want to be sure that are clear. A pour-over will is the part that we've been talking about. The will turns into a pour-over will when you have a trust. It pours over to the trust anything that you put outside the trust. Property agreement on community property. And I told you why community property was so important, because of the taxes. And that's the reason you need to make everything community property. If you came here from Illinois and you've been married for 50 years, there's no reason to have separate property. Am I right on that, Craig?
Yes, you are.
Okay. You want to talk about it?
Yeah, it is.
Okay, so keep in mind that powers of attorney are only valid during your lifetime. When you die, they stop. So they're only good during your lifetime. And most of these powers of attorney that lawyers do are what we call springing powers of attorney. They only go into effect if you're incapacitated. How is that incapacitation established? Well, the power of attorney usually has a paragraph that says that the agent must get a statement from a physician stating that you're no longer able to manage your financial affairs. Now the agent then can act on your behalf. When you have a trust, probably the person you named as the agent in the power of attorney is the same person you named in the trust as the successor trustee. But there may be assets outside of the trust that you own that would be subject to the power of attorney. Real good example is IRAs. You don't put an IRA in a trust. If I have a $50,000 IRA, I create a trust, I transfer that IRA into the trust, I'm going to get a 1099-R in January of the following year. That would be a taxable transfer. So that exists outside of the trust. If I become incapacitated, then it may be that RMDs need to be taken. So my agent then would have the authority to take those RMDs, or if additional funds were needed from the IRA to provide for my care, my agent would have the authority to withdraw funds. The nomination of conservator, and of course, the conservatorship kind of goes hand in hand with the guardianship. So if I don't have a power of attorney, I become incapacitated, I don't have a trust, then it could be necessary for a formal conservatorship proceeding, the court proceeding, to give someone the authority to manage my assets. The more information that you can give your successor trustee, the better, about things that you would want done to you or not want done to you, things about the administration of your trust, what to do after your death in terms of the administration, who contacts Social Security Administration, contacting pension providers, any life insurance policies to make sure your successor trustee knows about them. And then the pour-over will is the will that works with the trust, as Sam mentioned, and then the community property agreement. There's only 9 community property states, and Arizona is one of them. And that the benefit to husband and wife, of course, the community we're talking about for community property agreement is the relationship of husband and wife. I don't know whether it applies to same-sex marriages. I haven't had that issue come up yet. But nonetheless, there's only 9 community property states, and the benefit is that upon the death of the first spouse, any assets that have appreciated in value over time gets a new stepped-up basis. So a real simple example. Let's assume my wife and I bought IBM stock. We invested $10,000. Now it's worth $100,000. We sell it today, there's a $90,000 gain. It's going to be taxed at least 15%. I die today, we have agreed that all of our assets are community assets. That's what the community property agreement does. The basis is stepped up to the fair market value. So the basis is no longer the $10,000 purchase price, it's the $100,000 fair market value. So you can turn around and sell it, but there's no gain.
Donald gets a second chance. You're not gonna get a second. I'll tell you the story that's in that article was written in 1980. This guy was in Idaho and he went out goat hunting in the fall. A big snowstorm came when he was about to leave the hunting site and he didn't come home. By February, they decided he had died. And 2 courts had actually declared him legally dead. And he comes home and he says, "Oh my goodness, what a wonderful life I've got. I need to do an estate plan." Well, you know that he didn't do that. But the point is, he got a second chance to do it right. You're not gonna get a second chance. I'm not gonna get a second chance, so you need to do it right the first time. You got some comments on that?
Well, not directly perhaps, but I'm just thinking about when we probate a will, the probate registrar, the court, does not even require a death certificate of the decedent. Amazing. So think about this. My father has 1 child. We're on the outs. He's wealthy. He's in Europe. By the time he comes back, I've been appointed as personal representative and I've wiped out his estate. I mean, that's possible.
We're done for today. Hang out here as long as you want to ask us other questions.